Welcome back, and again, a special welcome to those who are watching us via live streaming, made possible by a grant and support from the State Justice Institute. My name is Scott Griffith, President-elect of NACOM, and we're really pleased this afternoon to have the two authors of the book, American Judicial Power, the State Court Perspective, talking to us about their book and about some important topics that they raise in it. The session is going to be moderated by someone who many of you know. He probably doesn't need a whole lot of introduction. Marcus Renkensmeyer, seated just here to my right. Marcus is he's a past president of NACOM, and he's graciously offered to moderate the panel. The book, which is here, is a really clear articulation of the role that state courts play in our system of governance. It's got abundant detail and reference material in it that provides some really interesting and helpful legal and historical context, and touches on, and I think this is one of the most interesting and helpful parts of the book to our audience, some of the unique challenges that face the judiciary in these days. So with that, I'll turn it over to Marcus. Welcome, and thank you.
Scott, our thanks very much for the opportunity, and thanks to the Planning Committee as well for including this type of a session. I'm just so pleased. I'm really honored to be with these two folks today. And I think some of you in the past have met Chief Justice Munez from Oregon, and he, in my mind, is a true judicial leader, and I want to thank you for being here, Justice. Mike Banger is with the courts in Ohio now as their director of state courts, and has also served as a state court administrator in two other jurisdictions. And what we're going to try to do in a short time, I could use the whole afternoon, but we're going to try to give you an overview and also some of the key concepts of this new publication. And we'd like this to be as interactive as possible. So we've got two microphones roving, and I know ordinarily we would wait to the end of the session for comments, but we would like you to interrupt us and challenge us along the way, and the chief will handle any really difficult questions. How's that? Now, maybe just to set the stage, and I want to talk as little as possible to make the best use of our time, but I do want to talk about publications generally for just a minute or two. In my mind, a lot of the organizations and professions really are sort of best judged, best understood really through the kinds of publications they would have. The depth of thinking, the scope of thinking, and whatnot. And I was just privileged years ago to serve as your editor for the Court Manager. And I was impressed, I still am impressed by kind of this steady stream of articles, best practices, and the like. And we see the same with the Justice System Journal, Judicature, of course the Judges Journal, and other publications. But in my mind, it's very few and far between when we have a book of this magnitude that would come out. And I thought about this. I was in a meeting the other day. We're still talking about Ernie Friesen, the Gallus publication, Managing Courts, decades ago. And we still use it. I still use that for teaching. I still pull quotes out of that book, and others of you do as well. And so when you think about this publication here, I think this is one of these that will be used not just for teaching, but to kind of generate really kind of deep discussion. And I think it does take our profession sort of to another level. The funny thing, just on a personal note, Justice, you had mentioned this to me in the fall, and he mentioned it. He's such a modest fellow that he was working on a publication, and with Mike, that should have been a clue. I thought it was a study guide maybe for the law students and whatnot. And it turns out, if you have a chance to look at this, it's a comprehensive look at the state court system, not just our adjudication function, but it talks about all the administrative roles of the courts, and probably most relevant for today, the changing role of the courts as we deal with bail bond, as we deal with the court access issues, the problem-solving courts and the like. So with that background, I'd like to maybe ask you, Chief, if we can, where did this idea come from, and how do you take a concept like this? I know you've done a lot of thinking and actually get it into a publication that would be available to all of us.
Thank you, Marcus, and thank you all for being here so quickly after lunch. Very appreciative. I would say this. I met Mike Banger, probably it was in 2009 at the University of Kentucky Law School at a symposium where we were both speaking, and I had written a number of law review articles, many of which had cited this guy named Mike Banger, and I was very taken with what he was thinking and what he was saying, and so we met then in Kentucky, and then went our separate ways, and I was just thrilled when was it? Probably now 3 years, I suppose. 3 years ago, when Mike called me and said, "I have an idea for a book." It was Mike's idea and concept, and I was very flattered to participate with him as a co-author. And I think what we shared mutually was this real appreciation of the importance of American state courts to our justice system, and how underserved or less understood the importance of state courts is. And I'll let Mike expand on that, but really it's the idea of understanding, as goes justice in America, basically it's how it goes in the state courts. And that really was what motivated me, and the chance to collaborate with Mike, I think is a wonderful thinker. The one thing I did contribute to the publication is the person who offices next to me is a man named Simeon Simonides, who is the foremost expert in the world on international conflicts of laws. And when Mike and I wrote our book proposal and were circulating it, we got some nice comments from university presses, but nobody, it was like, write it and then we'll talk to you. And Simeon was in my office. He's published 26 books, advised the EU in a variety of constitutional issues. Simeon was in my office, I'll say, having a glass of wine after 5, and he saw our proposal, and he asked me about it, and he took it home over the weekend. And I said, we could use maybe some advice from you, Simeon. And he read it, said, nope, this is perfect. I have a contact with Elgar Publishing. And I think in 2 weeks we had a contract. And Elgar is a fairly renowned international academic publisher. And that's how we got started. And with that, I'll let Mike tell you about his thinking, how we got into all this.
And so what Paul reemphasizes is it's who you know, not necessarily what you know. For those of you who know me, I've spent a considerable amount of time in the last decade and a half working overseas, and working with judiciaries in places like Kosovo and Egypt and Macedonia. And it was really a life-changing experience, because what it exposed me to was the reality that people think about the world differently. Not necessarily good or bad, just different. And one of the things that I had been involved in when I was in Europe is I got involved with some judges from Germany, from Italy, and from England, primarily working in Kosovo. And then I started reflecting on the American judiciary and how much the focus of what we talk about in our civic dialogue is, I think, inordinately placed on the role that the federal courts have played in shaping America. And I'll give you, if you want an interesting experience, this morning when I was having coffee at Starbucks, I got onto Amazon and I typed in the term federal judiciary, and the number of books that came up was somewhere in the neighborhood of 10,800. And I typed in the term state judiciary and I got 12,000 books. Now the problem, of course, is state judiciary also encompassed everything that involves the United States judiciary, the federal judiciary. So I tried to wean it further and further down. And I finally got to the point where I identified somewhere in the neighborhood of maybe 1,200 hits. And I'm not quite sure how I got these, but a bulk of those hits were about state seals on bathing suits. So I kept trying to go further and further down, and literally outside of maybe Robert Karp's book in 2010 about the state courts, there's virtually nothing out there about the role that the state courts have played in America's public life. And the problem with that, as you all well know, is that 95% of the litigation that occurs in this country occurs in the venues that you help manage and run. And so there's this kind of, I think, disproportional analysis and a unitary thinking about the American courts that, in fact, doesn't exist. And so when I reached out to Paul and we started talking about this project, one of the goals, one of the things that we were interested in doing is trying to expose this enormous role that the state courts have played throughout the history of the United States. You know, there's a great line that states are the laboratories of democracy. Well, state courts are the laboratories of judicial power. And there's a part of the book that goes way back into history, and if you look at the history of our own concepts about law, the rule of law, the role of judges in the judiciary, a lot of that is actually anchored way back in our colonial and early state history, even though most of the analysis of our understanding starts in 1788 and moves forward.
And Mike, you mentioned about the number of cases, the volume, and I think the book also talks about public perception. Much of that is formed by the experience in our state courts. Well, let's delve into the book a little bit and maybe talk about this role of courts, state courts, when it comes to dealing with the Constitution, interpretation of the Constitution, and also how that would work in relationship to the federal judicial system. Justice, maybe you'd like to go ahead with that one.
Yeah, I think that Mike and I shared the view that most law students, or many of them, leave law school thinking there's only one Constitution, and not understanding the great history and the role that state constitutions have played, and not just in our history, but many constitutions, for example, many state constitutions contain what we call open courts and remedy clauses, which are enormously important to access to justice. When we're as we look forward, the concept of access to justice many times is rooted in the state constitution in one of these remedies clauses. And so it seemed hugely important to emphasize the independent analysis of our constitutions, that the state courts, the state's highest court, is the arbiter of those rights and responsibilities that emanate from the words of the state constitution. And it's the last word when you're interpreting state law. So it's hugely important, and it's been a really profound transition over the arc of time from, for example, I graduated from law school in 75, and most states in those days, those high courts were just interpreting to the extent someone raised a state constitution issue, were interpreting them lockstep with the federal constitution. And then I was privileged to live in a state with Justice Hans Lindy, was on the Oregon Supreme Court, and I think there's an argument about who was the father of independent state constitutional analysis, whether it was Justice Brennan or Justice Lindy, but shaping us in a way to understand that, and in our state, for example, our Constitution grants greater liberty interests to individuals than does the federal Constitution, because the state courts are free to interpret their Constitution as the words and the history provide. So I think that's an enormously important part of the world in which we live. And most people, this is just to repeat something you said, Marcus, but people do not differentiate between the kinds of courts. And so most Americans, most people will have their experience in a state court. And our legitimacy as a court system, as a justice system, I think is dependent on all of us in the state court system, because that's how people's perceptions and where our legitimacy has to come from. It's not just, and we'll talk about this later, it's not just enough to have a constitutional mandate to be a court system. The public, it's the trust and the confidence that has to continue, that really what makes us uniquely American, and that stems from the state courts.
If I can, the interesting thing about the open courts and right to remedy clauses is in virtually every state they're contained in the Bill of Rights. They're not directed at the articles that contain the state judicial structure. They're directed at the people. And I think one of the challenges that we face in state courts is giving meaning to that. What does it mean to have access to justice? What does it mean to have a right to remedy? The tendency, particularly in recent history, to start giving some embodiment to that, I think gives state court leaders the opportunity, as we've throughout this conference have been talking about, what does it mean to have access to justice? And not just in a physical sense, but in a conceptual sense, in a fairness sense, in a sense that people have faith and confidence. The thing that I like to think about when I think about state courts is you can be constitutionally legitimate and totally irrelevant. And I think the challenge today is to not just rely on the fact that because the Constitution says we have to exist, that makes us relevant to the population, that makes us relevant to the people that we serve. And that whole issue of access to justice, which is emerging increasingly, is not simply a question of legitimacy, it's a question of relevancy.
I think many of us in this room are familiar with de Tocqueville's Democracy in America, 1835. Frequently quoted passage is where de Tocqueville observed that, and he used the word political, that every political question in America is sooner or later is resolved into a judicial question. And of course, I would substitute not just political, but legal, social, environmental, economic. The point here is that we were trying to make is that the state's highest courts sit at the sort of the intersection of the state's public policy. And I can use my own state as an example. Oregon, the bottle bill, which was one of the first recycling bills, we have the public beaches in Oregon. These kinds of things all were challenged in the Oregon Supreme Court. And so those policy things that many generations of Oregonians now take for granted were all vigorously challenged in court, and the state Supreme Court had a role to play, a significant role to play in that. And I think we all know they were the first ones to address, for example, the question of same-sex marriage, and it goes on. These all are in state courts, and that's been our history. And that's one of the things we were trying to emphasize in the book, that important role that state courts play.
Yeah, thanks, Chief. And we again want to invite any questions or comments along the way. We'll just kind of look for a show of hands. Mike, I was struck by just the layout of the book. The first 3 or 4 chapters, a lot of the historical background, kind of the big context, and then case adjudication. But you have dedicated, I think, over half the book to administrative functions of the court. And it's not just court administration, but I was interested, there's bar regulation and judicial conduct and the like. And could you talk about that a little bit?
Sure.
And that's the part I thought would be really relevant to the group here. And I just really encourage you folks to, if you have a chance to read those sections, well, you should read the whole book, right? But I think you'll find it to be really very helpful. And
we started with the premise, and I think it's a valid premise, that there is no such thing as a definition of what judicial power means. The kind of academic presumption is it's the right or the obligation of judges to decide cases. But if you look at the span of state judiciaries in this country, one of the things that becomes obvious very quickly is the enormous diversity that's at play within our state court systems. And I think that's a good thing. State courts manage everything from the bar. There is extremely limited federal involvement in the management of the bar. I am fond of saying to my friends who are on the federal bench, I like to remind them that they are judges of limited jurisdiction, and that state courts are courts of general jurisdiction, and so when even though there's this enormous emphasis on the role that the federal judiciary has played in the history of the United States, it is somewhat limited, confined not only by the federal Constitution, but the roles that have been assigned to it. I'll take Oregon, for example, or when I worked in Missouri, state courts are intimately involved in drawing legislative districts when the legislature can't do it. In Missouri, under the Missouri Constitution, if the legislature can't agree on a district, then the Supreme Court appoints 6 judges from the appellate court to draw the legislative districts. And as Tom Simon, the late clerk of the Missouri Supreme Court, used to joke, in those years when we're drawing the districts, we don't have budget problems. It's only the following year that we have budget problems. It's managing the bar. It is, to some degree, operating in an unconstrained way. Many of you are on the front lines of the problems that we face as a society. The ability to create specialty courts to deal with specialty problems. I mean, the whole drug court movement started in the state courts. We now have the veteran court movement in the state courts. So what was striking to me as I was involved in this project is that we really do have to kind of take off the blinders and stop assuming that we all agree on what it means to be a judiciary and to exercise judicial power, and take some renewed comfort in the fact that we can be creative and we can be innovative, and we have done that throughout the history of America. I mean, state courts have been on the vanguard of virtually every major change that has occurred within this judicial branch of government. We all like to cite back to Marbury versus Madison, but the historical fact is that judicial review started in the states well before it was incorporated by John Marshall in his Marbury versus Madison decision. We should, instead of citing to Marbury, we ought to be citing back to 1782 and to 1780 when the state courts in New Jersey and Virginia began to kind of give life to this concept of the role of the judiciary in terms of managing the relationships within government. So there's the point is that there is this tremendous diversity that we can all learn from. There's this tremendous role that we all share, and it doesn't necessarily need to be confined by our assumptions of what it means to be a court or what it means to operate within a judicial system.
And Chief, maybe I could ask you, in that discussion, there's also mention of advisory opinions issued by the courts and the like, and I know that would be new to some of us or not maybe fully understood.
Well, I think the emphasis, to draw on what Mike said, is the unique nature of the work of state courts given the state constitution. So there, I think, our book points out, I think there are 6, maybe 8 states that actually provide that the highest court can provide advisory opinions. In other words, as a way to avoid litigation from unconstitutional acts. And we don't have that in Oregon. So a good example of you wish you did, for example, is we have a lot of direct democracy in Oregon, meaning we have the initiative process, which has defined, for example, in Oregon, the sentencing policy in this state. Well, oftentimes these initiatives are poorly written, and they end up being found unconstitutional by the state courts. And of course, if there were provisions for advisory opinions, we would be able to avoid some of that whole problem. And we've got a section in the book because Massachusetts is one of the best known courts for being able to give advisory opinions, and we've got examples in the book of how that worked and how important that was, given some very difficult social policy issues that were before the court at one time in Massachusetts. I think, to draw on something else Mike said, the plenary authority of the state's highest court to regulate the practice of law is hugely important. The disciplining of judges is another unique aspect of the courts, which people leaving law school, lawyers, have no concept of these things and how important they are. And in fact, in Oregon right now, we have, I think, the first case in the country in which one of our trial judges is going through the disciplinary process because he publicly stated he would not perform same-sex marriages. So you see, we're on the cutting edge of how does that all work. This is what we were emphasizing, is the unique nature of American judicial power as exercised through our state courts. I think the innovative aspect also. I don't know if Jeff Hall's in the audience. Jeff, are you here? Maybe he cut out. I don't know.
There he is.
All right, Jeff.
Welcome,
I'm glad to see that. But in Deschutes County, where Jeff is the trial court administrator, there's a very innovative program being used where unrepresented people in family law can waive the rules of evidence and a variety of things. These are the kind of innovations in state court that are important. The move to therapeutic courts and problem solving, which we're now starting to move into family law, and the state courts are taking the lead in moving away from the adversarial system that, in my opinion, promotes the instability of families and children, and moving toward the innovative, more problem-solving mode. These are the things that we're trying to emphasize through the book.
And I know that involves a lot of work with stakeholders and the like, and I wonder if you could talk about, and I know this can be sensitive, but working with the legislature, working with other branches of government, and I'd like to hear from both of you on that front.
Well, Paul raised the issue of state constitutions, and I think, not to get overly conceptualized, but I think sometimes we think about state constitutional law the same way we think about federal constitutional law, and particularly when it comes to the issue of rights. And that is that there's a wonderful book written by a professor at Princeton. Her name is Emily Zach, and it's called Looking for Rights in All the Wrong Places. And the kind of rights narrative that you often see in academic scholarship and popular discourse is, I have this right to be free from something. You know, I have a right to be free from government oversight or government interference. And if you go through the Bill of Rights, it's Congress shall not. It's not Congress shall. The reverse of that takes place in a lot of our state constitutions. And part of that is because states possess the nation's police powers. That is, the states are the primary polity that is responsible for protecting public health and welfare. And so citizens, Paul made reference to popular democracy, citizens have injected in state constitutions not simply restraints on the legislature, but also mandates for how that police power is supposed to be exercised. And so you have probably the most famous example is you have a right to education. You have a right to, in many states, the term adequate is used to describe or to define what is meant by an education. And of course, you have disputes about what adequate means, and that's when state courts come into play. It is not a restraint on government authority. It is a directive that public leaders exercise public authority in a certain direction. I think unlike the cases that often come before the federal judiciary and its relationship with Congress, the state constitution defines a very different dynamic at times with the relationship of the state judiciary and the state legislature, and at times a dynamic that can be much more intense and collision-based. You tell legislators they got to do something. That's about one rung further down than telling them that they can't do something. And yet that's what the state constitution says. There's also interesting aspects of the state constitution where judiciaries find themselves right into the middle of the legislative process. For example, when I was in Missouri, we had what were called the Hammerschmidt rule. And basically, Hammerschmidt was a case name, and it came out of the fact that the Constitution prohibits the legislature from avoiding the single subject rule. That is, every bill has to be a single subject. It has to embrace relevancy. You don't have these huge omnibus bills in Missouri. And that's what they tried to do. And they violated the single subject rule. So not only do you have this dynamic where you have state courts telling legislatures what they can or cannot do relative to the exercise of public power, you can also find yourself in this dynamic where the state courts are telling the legislature what its process ought to be. And that oftentimes can be both politically as well as public relations wise, that can be a real point of contention and collision.
I think to take off of Mike's point, this whole question of judicial restraint and what judges do arises in the state court context, and particularly in the financing of public education, as Mike referred to, which is uniquely the legislature and the state constitutional, the state's highest court, getting into all that. And if you look around the country, you'll see that those are the issues that create contested elections for the state's highest court, is when legislators or public begins to believe that the state highest court has injected itself into public policy areas where, for whatever their reason is, they feel they're not qualified to do. And one of the sections we have in the book is about how judges are appointed, elected, a variety of things. And it was a great education for me in researching those topics. And so those of you who are from South Carolina, for example, or Virginia, and finding that the legislature actually elects the judges to the state's highest courts comes as a shock to people. But the whole process of electing judges and the special interest financing now of judicial elections is really, in my humble opinion, is an extreme danger to maintaining the public's trust in the impartiality of the courts. And the more we inject money into the court system, and it is now into these elections, and I can give you example, in the state of Washington, there are 3 justices up for election, and I think you can trace it all back to their opinion on where they held the legislature in contempt with regard to the financing of public education. And I think the same thing is occurring in Kansas. So these are the things where the state courts are in the forefront of all of these kinds of as de Tocqueville said, political, social, legal issues.
Maybe to ask, given those kind of inherent tensions, any sort of practical suggestions you might offer? I know both of you have worked effectively with the state legislatures over the years, but anything you might
Yeah, I have some. I think that one of the things that we stressed in the book is that speaking, and I think this applies not just to judges, this applies to the administration of the courts, is we no longer sit in the courthouse and wait for the public to come to us with a case, and then we adjudicate it. Our judges, our administrators have to interact with local folks, with the legislature. All of this is about funding. So one of the points we make in the book is that certainly the framers of the federal Constitution and the framers of our state constitutions wanted to ensure decisional independence. But they didn't think about the concept of institutional independence, because when those constitutions were framed, courts were just a collection of locally funded courts. They didn't envision the monolithic state court systems we have today. And so there is no protection. Well, there might be in a couple of constitutions. There's some language that might give some hint that funding needs to be at a certain level, but sustainable funding is, of course, to me, one of the most important aspects of our ability to remain relevant. And I think we'll talk about that later, what it means for the court system to remain relevant. But we have to interact with a variety of actors, not just to sustain our funding, but to meet the public's needs and the public's expectations of what they want to see in a court system, and how we deal with the younger generations that are now using the courts and those types of things. So I think those are hugely important things, and we tried to bring that to the front in our book.
Mike?
I think Paul probably brings about the most important issue that we face today, and that is we cannot expect the public to support that which it does not necessarily understand. And my own view is that for a very long time, we have not, as institutions, perhaps individual courts and areas, but we have not kind of been able to speak with much of an institutional voice about some of these important and emerging issues. And I think increasingly today, we need to develop the capacity not simply to interact, but to, as much as we can, stop disagreeing with each other. I can remember walking into the office of a senator in Missouri, and I said to Senator so-and-so, I'm here to talk to you about Senate Bill 123. And he said, oh, that's good. He said, because Judge so-and-so was just in here 20 minutes ago, and he wanted to talk about Senate Bill 123, and I'm just wondering which of the two stories I'm supposed to follow.
Oh, my God. Does that sound familiar?
Yeah, so I think the challenge today is internally within the state judiciaries, a sense of collegiality of common purpose. I think the external challenge is the challenge of engagement, so that people really do believe that these are institutions that are working for them. I think we live and we work in an industry that easily breeds cynicism. I think it is. I think, I mentioned on Sunday when I was talking to some people, the same person at the counter for the 24th time, and you kind of want to throw up your arms, and you do that day in and day out and day in and day out, and your level of cynicism and your level of skepticism just grows exponentially. And I think what we need to remind ourselves at times, at a very operational level, because you're on the, many of you are on the front lines here, is that it is better that people bring their problems into this forum where they can be rationally, deliberately dealt with, than it is to become so cynical that they just assume the institution can't work for them anymore, and they decide to figure out a different forum in which to resolve their differences. NCSC has done some interesting polling data, but my own experience of working in Kosovo demonstrated what happens when a justice system fails. I have become convinced, having worked in post-conflict and pre-conflict environments, that if you want to trace the absolute collapse of a society, the absolute collapse of public authority and government to anything, it ultimately traces down to the failure of the justice system to provide what people have confidence in terms of the delivery of justice. When people no longer think that there is an off-ramp, an avenue by which their problems, their legal problems, can be dealt with in a rational, deliberative, and fair manner, they'll figure out how to find fairness, but it may not be the fairness that we want.
Let's take a look into the future if we can. I know you have a whole chapter on emerging policy issues, and Judge, I've heard you say several times now, let's be concerned about the relevancy of the courts and whatnot. I know there's a lot of emphasis on technology and court access, so maybe you could kind of paint a picture, and again, from the standpoint of the administrative role in those kind of improvements.
Yeah, I have thought for years, and we've got we touch on this in the book, that we as an institution are in a battle for relevance, that our customers, if you will, I don't have my cell phone on me right now, but I think that they take out their cell phone and they look for the app to navigate the court system, okay, or the app for their lawsuit. In Oregon, we've found, for example, that many of our self-represented litigants are engineers from Intel. And they can't understand why there isn't an app to navigate the court system. There should be. But the generations that would be our court users, I think, have very little patience for what we would consider the court norm, the reams of paper, the delays, the lost files, the delays in judgments, those sorts of things. And so I think we as an institution need to be meeting the needs of our customers. So, for example, when I went to the legislature in 2007 and said in my opening statement, I want to build the largest courthouse in the state. I want to build a virtual courthouse that's open 24/7. And I think that these are the kinds of innovations that we have to continue with to remain relevant to those people who would use the courts. And I think that the state courts, that we're doing a very good job of that. While the federal courts were sort of the first ones to move to some electronic use, I think we have surpassed many of that. And the idea is not to make all of our jobs easier, but to give the public greater access and easier access to court operations, fines, fees, all of those things that they take for granted when they use Amazon, and they want to use it in the court system. And I think we're doing a really good job about that. But I think that's part of our battle for relevance, and it also gets into the oft-repeated thing. We have to have sustainable funding. You cannot turn court operations or court programs on and off like tap water, given the funding. And so that's the battle that I see us waging, is this relevance that we have to continue.
I think also it's kind of an irony, because legal problems can be enormously complex problems. And yet, if you look, for example, at some of the data that NCSC has collected about the demand for self-service, about the demand for technological access, and I think one of the most difficult statistics is the fact that 67% of the people, if they have a dispute, would rather be someplace else other than in state court. When I talked to some new judges in Ohio about that, afterwards, one of them came up to me and said, well, people want to do mediation because it leads to far more sustainable outcomes and it reduces the workload on the courts. Mediation, for example, to the degree that it produces more sustainable outcomes, is good. To the degree that we look at it as a way of reducing our workload, I think that's bad. Because if I was Amazon and 2/3 of my customer base said I'd rather be shopping someplace else than with you, I wouldn't be anymore. And that's why I get to the notion that we can be constitutionally legitimate, but that does not necessarily ensure that we are socially relevant. And the great challenge, particularly with new generations coming up, expectations about how they interface and interact with government, and not just new generations. My wife and I just got a new car, and I told this story on Sunday. I had to go to the Ohio BMV to register the car. It was a 35-minute exercise to register a car. And I found myself, who by no measure, and my staff at the Supreme Court can testify to this, at no measure am I a techie. I found myself frustrated by the fact that I was taking 35 minutes out of a Saturday morning to stand in line, to go to the counter, and I counted the number of the minutes, the average number of minutes that people were at the counter trying to get their car registered, and it was 5 minutes. Everybody was 5 minutes, and I thought, there's got to be a way that I can interact with this public institution in a much more effective and much more efficient manner, and I think the same challenges face us.
Thanks, Mike. We'd like to invite some questions from you folks. We wanted this to be as much of a discussion as possible, and I think we have 2 live mics to bring out to you folks. There are no bad questions, we hope.
I've got a question to get us started.
Thank you, Scott.
Maybe.
Thank you.
I think the comments that you've made, Mike in particular, about the difference between legitimate and relevant are really important, and this is a question for both of you. It seems to me that our branch and our courts are our most relevant and our most stable when we are acting on a vision and energy that's derived from within the branch and not dictated from outside. So in terms of, in your study, did you come across models of internal governance, institutional governance at the state level, judicial councils or committees or what have you, and at the local level, relationship between administrators and presiding judges? Any thoughts about how we can derive relevance through models of organization?
Well, let me start by saying I've worked in a unified court system, a semi-unified court system in Ohio, which is enormously decentralized, very locally focused. I don't think that there is a formal model. There's no one size fits all. I mean, each of our systems, what's fascinating to me about when we were doing the book, each of our systems has its own culture to it, and it has its own traditions to it. And I worked on a project in Kosovo for 3 years, and at the end of it, I was asked to go up to meet with the USAID director, and she said, so do you have any advice for us? And I said, yes, changing the trajectory on judiciaries is a cultural experience. And we would get these projects coming out that would say things like, within 3 years, the Kosovo judiciary will be fully independent and this, that, and everything else. And you're really changing and dealing with culture. And I think I guess if I were to say that there is a model, it is a model in which we see ourselves not necessarily as totally divorced independent actors. It is a model in which we see ourselves as part of an institution that may have different but complementary roles within it. And that calls for a level of engagement, conversation, dialogue, and discourse, not only amongst ourselves, but with our constituents, to make sure that we understand each other and they understand us. Whether it's a judicial council, whether it's the Supreme Court, whether it's some hybrid of something in between, I'm not so sure that the model itself is as important as the engagement and figuring out how you engage with one another within the courts and how we engage with those that we serve to make sure that we are listening to each other and we are understanding each other. And we understand that we have different roles to play, but those roles don't necessarily have to mean internal combat.
I think that on a very basic level, it's hard to describe which form of governance is ideal. But for example, in those states that, like Oregon, where we have a unified court system and the Chief Justice is the administrative head of the judicial branch. So if you think about those states where this occurs, how is the Chief Justice chosen? Ought to be a question that should be relevant and asked now. Not all of us who serve in the state's highest court have the abilities to manage a court system. And so, for example, there are many states in which the Chief Justice role just rotates. Every couple of years. I don't know how you'd get anything done, but then there are states like that. But they just rotate without a thought about whether the person really has the passion and a vision for where they want to lead the courts. And at this time in our history in particular, we need to have court leaders who are committed to the idea of a vision, execution, and implementation. And that to me ought to be the three things you're looking at and where you're taking a court. So I think that some true critical analysis of who leads the courts is important, and it's not something we really like to do. And then to follow up on something Mike said, because there is no institutional independence that's protected through the Constitution, our legitimacy, our trust by the other branches of government has to be earned, and it has to be earned every day. And so I think we have to position ourselves in a way that we reduce, if you will, the misunderstanding between the branches. And that's not necessarily a simple task, because although many of these legislators are very well-meaning people, they have really no familiarity with the court system. None whatsoever. And so you have to overcome their idea that, look, when you come to me as the leader of the judicial branch and you say you need X funding, I'm balancing that against health care, education, children, the most vulnerable populations. How can you tell me that you have to have this salary for your judges or these? And so those are the things that I think require education, training, conversation when we're governing the court system, to be able to work with all of the actors externally, I think is important.
Other questions, comments of this whole group? Patty, thank you. Found somebody. Well, we know it's after lunch and everybody's a little quiet, but we have such terrific resources here. We'd really like to hear from you folks. So, yeah, please.
Yeah, my question has to do with the courts, and the judiciary has a lot of knowledge and expertise about making systemic change, positive systemic change, and particularly criminal justice reform in those areas. So in looking at that, what would you think, how far afield can we go? Like, where is the appropriate area from a policy standpoint, or do we go farther? Is it just decision-making in cases? It goes beyond that in terms of legislative areas? I'm just curious if you have any thoughts on that, because it seems a natural place for the judiciary to go because we have such knowledge about that area.
Thank you. Go ahead, Mike, please.
Well, I think one of the challenges that we face is we can't be the institution that protects the rule of law and then decides that the rules don't apply to us. It's kind of keying off of what Paul said in terms of relationships with the legislature. I think one of the things that we need to be highly cautious of, whether it's dealing with a state legislature or a municipal legislative body, is being respectful of their role. Thomas Jefferson, I think it was Thomas Jefferson who famously said, the judiciary is that branch of government most interested in protecting its own independence while invading the independence of everybody else. And so I think, and I'm not trying to be too evasive, I do think it's a balancing question. I think it's a balance in terms of defining what is the role. I mean, state courts have been enormously innovative institutions in terms of delivering services. Again, all you have to do is look at the therapeutic court movement that has evolved within state courts. But I think we need to be careful not to take the position that we operate without restraint. I think it is important that we use the mechanisms that are provided. I think it is important that we respect the constitutional balance of powers. I mean, Paul's correct. I mean, if you're a legislator and you have the Chief Justice or the Administrative Director and they're saying, I need X, 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 the reality is they're balancing that against education, healthcare, public safety, all of these other kind of things in which they're trying to balance these competing demands, often on limited budgets. And I think being insensitive to that fact makes us look disengaged. It makes us look as if we don't care. It makes us look as if we're elite and we're special and we're not part of the system. We exist outside the system. And I think that's sometimes where we get jammed up.
I agree with Mike completely about those things, but I think certainly myself, I had some transition in my own thinking, and I'll use this as an example. I think most people considered my judicial philosophy to be on the side of very restrained jurist. In other words, not wanting to mix to the extent you can avoid it in the policy questions, respecting the legislature's role. However, when I was asked by the governor to chair a commission on public safety, which was really a public policy body, I chose to do it. And I did it because I thought I could bring something to the table from years of experience in working in this happened to be in criminal justice, working in the criminal justice system, and it was an opportunity to interact with legislators in a way where I was not asking for something, and in a way that you try to get them to see you as a resource for the things that are going on. And if you can expand that, where it's not just the chief or the state court administrator, but you have other trial court administrators and judges who can play roles like this, where they're seen as resources, as opposed to we just show up for the legislative session with our hand out. I think it makes an enormous difference. And then I think it's a delicate balancing question when it comes to this policy business. It's a very delicate balancing system, but I think you can work with legislators to bring innovation in dealing with social issues that come before the court or other kinds of things. So it can be done. I think but we have to always try to be respectful of what each branch is supposed to do.
And just to follow up on something Paul said and go on, I mean, the judiciary remains the most trusted branch of government. And I don't think that we should lose sight of the opportunities to leverage that trust for the betterment of the public. Those of you who run specialty courts know that at the end of the day, if the judge says, we need to meet on X and we need to bring these stakeholders to the table, more often than not, the stakeholders will come to the table. And so I think we can leverage what trust and confidence we have in two ways. One is to continue to build our interactions in public trust and confidence in the court. But secondly, I think we can become involved in policy discussions utilizing that trust as an opportunity to expand the dialogue, to expand the opportunities for engagement, to expand the thinking about how we can deliver justice more fairly, more expeditiously, more effectively. I don't think we're at a time where we can sit in offices and try to figure that out on our own.
Yeah, such a good point. The notion that a judge or administrator can convene the stakeholders, bring folks together. That's terrific. I know our time is always up, almost up, and I know we started a minute late, so I'm going to ask just maybe for any final thoughts you would have, try to kind of just summarize any last notes. I know for me, the book has just been sort of inspirational, and I really hope you folks will get a chance to look at this. Let me mention also, there's a breakout session with these two panelists, I think immediately after. Right. And I'd encourage you, if you're interested, maybe even a little more informal discussion there, and more questions from you folks maybe. So, Judge, just any final comments having authored something like this?
Well, I would begin by saying I can't tell all of you what a privilege it was to collaborate with Mike Benger to write this book. It was really an honor and a privilege to have that opportunity. And I think all of us in this room share the idea that our state courts are enormously important, and what we can do to make sure the public not understands that and then we enjoy their confidence is really one of the key aspects of what we're trying to do. So that said, and I also want to thank NACM for giving me the opportunity. I'm a retired guy, so being somewhere is a great thrill. Thank you.
And you love this. This is his retirement work, okay? And if I could just he actually has a novel in the works as well. So the judge, and he teaches law school, so you're hardly retired in my mind. I don't know, Chief. But go ahead, Mike, please.
I would
Sure.
I would leave you with two thoughts. In addition to thanking Paul and recognizing his tremendous contribution. It was fun because we were trying to write this on a 9-hour time difference. Yeah. Because I was still in Europe when all of this kind of started off. The first one is I would go back to what I said about cynicism. I think we're in a business because of the nature of what we do every day and the folks that we deal with that it is incredibly easy to become cynical. And I think it's important to fight against that cynicism, particularly for those of you who are on the front lines of delivering justice. I have the remarkable luxury of sitting on the 7th floor of a grand old courthouse in downtown Columbus and thinking about things And I know that's different than being at the corner and trying to manage all of these interactions that you have every day with the public. And so you deserve a tremendous amount of respect for the difficult jobs that you do. But I do caution that it's, in my experience, easy to become cynical. The second thing I would leave you with is you are leaders of remarkably diverse and potentially remarkably innovative institutions. And if anybody has responsibility for innovation, for making us more relevant, for making sure that justice in America is fairer, both in fact and in perception, it's all of you. So I congratulate you for that work, but I encourage you to continue to work in that vineyard, if you will, and to fight the tendency that this business can breed, which is a tendency toward really human cynicism about other people.
So, Mike, I view that as a call to action. We appreciate that. And on behalf of the association, we just simply want to thank you for being here, both of you. It's really terrific to have co-authors here today.
Thanks, Marcus. Thanks to you.
Thank you, Marcus.
Appreciate it.
And then I think housekeeping, just to remind everybody, we want to stay on schedule, 2:15 breakouts, and we hope to see everybody this evening on the social event. So thanks again,
Great.
everyone.
Thank you.
Okay, thank you.
Thanks, Mike. Thanks, Paul. Very good. Marcus, thank you. Of course. Thank you.